Welcome to FedSoc Forum webinar call. Today, April 23rd, 2025, we're delighted to host a discussion on Kennedy versus Braidwood Management, looking back at the oral argument. My name is Kayla Kleist, and I'm an Associate Director of Practice Groups here at the Federalist Society. As always, please note that all expressions of opinion are those of the expert on today's call, as the Federalist Society takes no position on particular legal or public policy issues. Now, in the interest of time, I will keep my introduction of our guest today brief, but if you'd like to know more, you can access his impressive full bio at fedsoc.org. Today, we're fortunate to have with us Timothy Sandifer, who's the Vice President for Legal Affairs at the Goldwater Institute's Scarf Norton Center for Constitutional Litigation, and he holds the Duncan Chair in Constitutional Government. He's the author of 8 books, as well as more than 50 scholarly articles on subjects ranging from Indian law and antitrust to copyright law to the constitutional issues involved with the Civil War, the political philosophy of Shakespeare, ancient Greek drama, and Star Trek. He's a frequent guest on radio and television, and his writings have appeared in Reason, the National Review, the Weekly Standard, the Wall Street Journal, and the Objective Standard, where he is a contributing editor. He's taught classes at Pepperdine University, George Mason University's Antonin Scalia Law School, and at Arizona State University, where he was the Barry Goldwater Chair in American Institutions. He's also an adjunct scholar at the Cato Institute. And I will leave it there. A last note throughout the program, if you have any questions, please do submit them via the question and answer feature, likely found at the bottom of your Zoom screen, so it'll be accessible when we get to that extended portion of today's webinar. I'll ask that all questions submitted there, A, pertain to this discussion, and B, end with a question mark. With that, thank you all for joining us today. Mr. Sandifer, the floor is yours.
Thank you so much. We were going to talk about a case called Kennedy versus Braidwood Management today. That's a case that involves sort of tangentially the issue that has been really in the headlines a lot lately that we call the administrative state. That is the regulatory agencies that have authority to write rules, investigate infractions of rules, and punish the violations of rules, all combining the executive, legislative, and judicial powers together in violation of the constitutional principle of separation of powers. And this issue of the validity and the workings of the administrative state has come up before the Supreme Court in a number of cases, and most recently in this Braidwood Management case. Now, the Braidwood Management case is a little different than cases that you've read about, such as the Loper-Bright case, which involves Chevron deference and things. In that this case involves a group called the Preventive Services Task Force, which started out as a merely advisory group, like a group of scientific experts whose job it was to advise the Secretary of Health and Human Services about how to operate federal health programs and so forth. But what happened was that when Congress passed the Affordable Care Act, also known as Obamacare, it transformed how this task force operates and made it into a kind of regulatory agency. That is, it allows the agency, or the task force rather, to write rules that automatically become law and are enforced by the federal government, or at least that's what the plaintiffs in this case say. And they say that that violates the Constitution's Appointments Clause, because if there is going to be a government official who creates some kind of rule that you have to follow, there have to be checks and balances on the person occupying that job. And one of the most important of the checks and balances is the appointments process, which says that the president appoints people and the Senate confirms them. Now, the U.S. Constitution's Appointments Clause subtly differentiates between the kinds of government officials who have to be nominated by the president and confirmed by the Senate and those who do not. That is, the Constitution says that superior officers, heads of departments, have to be chosen by the president and approved by the Senate, but inferior officers do not have to be. They can just be hired by the president or the government official in whatever process Congress thinks appropriate. So the question in this case is, if these members of this task force do occupy a role that's basically like the head of an administrative agency, so that their say-so becomes law, don't they have to be nominated by the president and confirmed by the Senate? That is, aren't they superior officers? Or are they just inferior officers whose role it is just to implement existing law? That's really what this case is about. And the case began out of certain religious objections to certain provisions of the Affordable Care Act. That is, this Preventive Services Task Force, their job is to specify what sort of preventative services, health care prior to some sort of crisis, what sort of preventative services must insurance companies pay for. You know, you go in to get your regular annual checkup to make sure that everything's okay. That's a preventative service. And do insurers have to pay for that, and how much do they have to pay for it, and that sort of thing? That is answered by reference to federal law. And who implements and creates those federal laws? Well, the Secretary does that, and the Secretary does that by relying on the recommendations of the Preventive Services Task Force. What they do is they say, well, you know, this test, let's say it's a cancer test or something. This test is a really effective test. It's affordable. It works well. So therefore, it's a good test, and insurance companies should pay for that as part of preventative services. That's the kind of question that this task force answers. And as I said, originally, the task force just passed recommendations. They just said, we recommend that the Secretary use this test for cancer instead of some other test for cancer. And then the Secretary would look at that advice and be like, okay, that sounds like a good idea. And that was how it used to work. Then the ACA came along, the Affordable Care Act. It came along and transformed this recommendation body into an actual enforcement body. Now their recommendations, when they say that some cancer test or whatever is good enough, now all of a sudden insurance companies have to follow that because the department implements their recommendations with no input from anybody else, or at least that's what the plaintiffs argue in this case. And if that is true, then the members of this task force should be selected by the president and confirmed by the Senate. The government, on the other hand, says, no. These people are inferior officers. They follow the secretary's say, so the secretary exercises supervision over them, and therefore they don't have to be nominated by the president and confirmed by the Senate. And it comes down to a statute. I have the language of the statute here, and you'll see why the statute is kind of oddly written. I mean, we're talking about the Affordable Care Act. Practically everything about the Affordable Care Act is oddly written, since it was kind of stitched together as a Frankenstein monster out of all sorts of policy ideas that have been floating around Washington, D.C. for decades before that, leading to, of course, an endless series of lawsuits over how to interpret and apply the Affordable Care Act. That's just my editorial comment. Anyway, the statute, here's what the statute says. It says, all members of the task force and any recommendations made by such members shall be independent and, to the extent practicable, not subject to political pressure. Now, a lot of this case turns on that phrase, to the extent practicable. And so I'll read that again so you get what I'm saying. All members of the task force and any recommendations made by such members shall be independent, comma, and to the extent practicable, comma, not subject to political pressure. Now, the government's position in this case, they say the members of this board are not truly independent of the secretary, because if they are truly independent of the secretary, then they have to be nominated by the president and confirmed to the Senate, because that would make them superior officers with nobody above them to give them orders, right? They want these officials to be inferior officers. And so they want to say they're not independent. And yet the statute says shall be independent and, to the extent practicable, not subject to political pressure. So the government has argued in this case that the phrase to the extent practicable means to the extent constitutional. Okay, now if you follow how that statute would read then, here's what it would say. All members of the task force and any recommendations made by such members shall be independent and, to the extent constitutional, not subject to political pressure. That would make a lot of difference, right? That would mean that these people must be inferior officers, because otherwise it would be constitutionally dubious. The problem with that is that that's not grammatically how a normal user of English would read that sentence. A normal user of American English would say that the phrase to the extent practicable only modifies the phrase subject to political pressure. And therefore, that would mean that the statute says the members shall be independent. And if the members are independent, then independence means they need Senate confirmation, right? So a lot of the argument that went down this week was over how to interpret this statute, whether these people are independent or not independent. Now, the government argues, no, they are not really independent because the secretary can fire them. And removability from office has, in many of the precedents on this issue of the Appointments Clause, removability from office has often been seen as the most important, if not the dispositive issue in determining whether or not somebody is superior or inferior. And that kind of makes sense, right? That is obviously, if a person can't be fired, then that person has no superior, and therefore that person must himself be superior to, must be a superior officer, can't be an inferior. If you're an inferior, that means there's somebody above you who can fire you. So it seems to make logical sense that if a person's removable, then that person is not a superior officer. That's not what the Court of Appeals said in this case. In this case, what the Court of Appeals said was, well, removability is very important. In most cases, it'll answer the question, but it can't be the only criterion. There are other circumstances to be considered. If the person in question is where the buck stops on a particular issue, then the fact that that person can be fired for some other reason would not make that person inferior. So to use an example that I put in the amicus brief that the Goldwater Institute filed in this case, imagine a police chief. A police chief can be fired by the city council, but nevertheless, the police chief is where the buck stops when it comes to questions about, let's say, the police uniforms, right? If the policeman shows up without a uniform, the policeman can be fired for that. The chief of police is the final call on firing that person, even though the city council could, in theory, fire the police chief. So the removability cannot be the end-all be-all when it comes to determining whether somebody is superior or inferior. And one thing that I thought was unusual about the oral argument, one thing that came up in this week's oral argument that I had not anticipated, were questions about how are these people appointed to begin with? This was a question that Justice Gorsuch raised. How is it that the members of the task force are even appointed in the first place? The statute actually doesn't say. The statute is actually silent on how they're even chosen to serve on this task force. What the statute says instead is that the secretary shall convene the task force, not that the secretary shall appoint the task force. Now, both sides of the case agree, they have reached an agreement that convene is the same thing as appoint. I don't know about that myself. The reason for it is that the term convene was used back when this agency or this task force was truly advisory. Back then, it makes sense. You wouldn't have to appoint anybody because there's no appointments in the first place. You're just asking a group of experts. So you could just say, hey, I'm going to have a group of experts. I'm going to, a kitchen cabinet is what they used to call it back in the day when the president would have a group of informal advisors, right? That's what this originally contemplated. Now that Obamacare has transformed the task force into a group of basically regulators, how are they appointed? The statute is silent. Instead, we all just sort of assume that the secretary can pick whomever the secretary pleases. Now, the question about removability, if the secretary can remove these members, does that mean that the secretary can also control the recommendations that they make? Again, you would think as a common sense answer that the answer would be yes, because if you can be fired for the decisions you make, then that means your boss is ultimately responsible for the decisions you make, right? But not necessarily, not under this statute. When this question came up in the oral argument this week, the question was, the answer that the petitioners gave, the plaintiffs rather, the answer that they gave was, actually, the decisions are not always reviewable by the secretary because what these people decide is they say, well, should this cancer test go on Schedule A or Schedule B or some other Schedule C, Schedule D, whatever it might be. Only Schedule A and Schedule D are implemented as a matter of law. And so that means if the task force chooses not to put a cancer test, not to give it an A or B rating, that choice not to do that thing cannot be reviewed by the secretary because they haven't done anything, right? So there's nothing for the secretary to review. And that means that their choice not to give something a rating is that's where the buck stops. And where the buck stops means they're independent. And if they're independent, they have to be chosen by the president and approved by the Senate. Another question that came up during Justice Jackson's questions that I thought was interesting was, she said, if it's true that these recommendations are automatically implemented by the statute, then why is there a waiting period? They make these recommendations about A or B ratings on cancer tests or whatever other kind of treatment. And there's a waiting period before that gets implemented and the insurance companies are required to provide payment for that. Now, the plaintiff's answer to that is that's to allow the insurance companies time to adjust their timetables, their schedules, their funding, and that sort of thing, which is a sensible answer. But Justice Jackson didn't think that was true. She said, isn't it really so that the secretary will have time to intervene and make a decision about whether or not the recommendation should go into law or go into effect or not? Right? She's imagining that the task force makes a recommendation, the secretary looks at the recommendation and approves or disapproves of it by choosing whether to fire members from the task force or not. And the answer to that the plaintiff's lawyer gave was, well, then that would destroy the word independent in the statute. The statute says independent. And everybody agrees at least this much. Everybody agrees at least that the word independent in the statute means that their recommendations should be independent, right? And so how would that work with independence? It wouldn't make any sense. Plus, there's actually a different part of the statute that causes the recommendations to go into effect. It's not that the secretary looks at the recommendations and signs off on them. The secretary can look at the recommendations, but only in the same way that you and I can look at them. Under the statute, those recommendations get automatically implemented under a different section of the statute that's not at issue in this case. And so that, I think, pretty persuasively shows that these task force members are the place where the buck stops, and therefore that even though they're removable, they nevertheless are superior officers and have to be appointed in accordance with the Constitution's Appointments Clause. The reason this case is kind of interesting and unusual as far as Appointments Clause is concerned is that the Supreme Court has never really gone that far. They've usually, in their Appointments Clause cases, they've usually said that that removability is enough. If you're removable, you're not a superior officer, and there you go. So this case gives the court the opportunity to open up the meaning of superior officer and mean that other government officials qualify and have to be appointed by the president and selected by the Senate. Now, why does any of this matter? Is this all just minutiae? Well, the answer to that is no, for two reasons. The first one is that this commission, this task force, if the plaintiffs are right here, that they have to be appointed in accordance with the Appointments Clause, this task force has now been around for quite a long time, right? Obamacare was 10, 15 years ago. So they've been around for a long time. They're making a lot of recommendations, even though they were not nominated in accordance with the Appointments Clause, and therefore their choices, unless subsequently ratified, would be invalid. And we're talking about all the choices they've made during however many years that's been. So that would have a significant effect. But it would also, in a broader sense, and what I think is a more important constitutional sense, it would have a great deal of effect, because our lives are today ruled over by so many agencies and boards and commissions that write the rules. You know, the idea that how a bill becomes a law, that, like from the old cartoons of I'm just a bill and I get voted on by the House and the Senate and then I become a law. I mean, that is mostly nonsense in today's pervasive regulatory state, where most of the rules that govern our lives are written by unelected, hired government bureaucrats whom you cannot even fire, whom Congress cannot even fire in some of these cases. So in a broad sense, the ability to have at least some check in the form of Senate confirmation is really increasingly important as the bureaucratic state takes up more and more of our power. This comes to mind in light of another provision of the Affordable Care Act, in which an agency is created. It was called the death panels back in the day, but this is a group that had the power to decide on what kind of treatments would be paid for by the government and not paid for by the government. And this commission had unreviewable authority. The statute gave it power to make these decisions without any kind of check or balance by Congress or the courts or anybody. Blatantly unconstitutional. Unfortunately, that question has still not been fully resolved by the courts. So not just in the realm of healthcare, but throughout most of the areas of our lives that the federal government regulates, this question of the Appointments Clause is crucial to ensuring that there's at least some check and balance against these agencies that can write and impose these rules. All right, I've rambled for a while about the meaning of the Braidwood Management case, and let's see if we have any questions.
Thank you. I really appreciate that summary of how we got to where we are, as well as some of the major questions. The questions that were notable in oral argument. I won't say
Yes,
major
you are
questions that
confusing this
evoked
with
something
the
else.
even equally obscure major questions doctrine of administrative law, but God forbid we get into today.
Yes, I don't think that was an issue here, so I won't bring up that conversation. And instead, we can turn to the questions from our audience. I'll issue that reminder that if you do have questions, you can submit those via the Q&A feature. And as those come in, I have a couple of my own I would love to pose. Starting off with the important but not dispositive nature of at-will removal power for principal versus inferior officers. One thing that struck me in oral argument was that Mr. Mupin, who I think argued for the petitioners in this case, did not go so far as to say just at-will removal power was enough. And sort of he stepped back from that very clearly in oral argument. Why might that be? Is it simply a not getting too greedy or not saying, hey, we don't need to go that far, here's the line? Or are there other things that could affect if they went to that sort of position and therefore they're trying to keep the court away from them?
That's a great question. I had not noticed that, but you're absolutely right that that did happen. You might have expected the government to come in and say removability is it, and since these people are removable, end of show. I think, though, that the very fact that the court took this case might suggest that they would be dissatisfied with that answer. Certainly, I would guess that Justice Gorsuch would be dissatisfied with that answer. Remember also that at least one member of the court, Justice Thomas, was actually the head of an administrative agency. So, you know, if you're taking a realistic look at how the administrative agencies work, as opposed to a formalistic look at how administrative agencies work, mere removability is not satisfactory. And I suspect that that is the reason why it is wise to not go in on this case with a clear rule of it's either this or nothing, because I don't think the court is interested. I think they would lose if you went in with that kind of an argument. This court has shown a great deal of sensitivity to how administrative agencies actually work in the real world. The Loper Bright case was elaborate on that question. Justice Gorsuch, you know, his opinions are very thorough about how these agencies operate. Cases like Sackett, you know, have shown that the court is really sensitive to the fact that these bureaucracies are given excessively broad authority and under mushy legal doctrines. And so if you go in there with a clear line, it's really not satisfactory. That's just my impression.
Got it. Thanks so much. An audience member asks about the fact that this case is obviously, it was granted under one administration, is now being argued under a different one. I think it was granted, it was Becerra versus
Right.
Braidwood, really alliterative, and now it's Kennedy versus Braidwood. Is there any difference or any change in the way that the case has been dealt with now that there's been an administration change?
No, there hasn't. And that is, you know, I was going to say disappointing from a limited government perspective, but I will say it's not all that surprising because we actually have seen relatively little change in the government's position due to the change of administrations. Now, part of that might just be that it's still early, you know, it's been only a couple months. And so the Justice Department has not decided to change its position on some of these things for that reason. And part of it might be that in the previous change of administration, the court expressed its displeasure on a couple of times at the federal government's change of legal position. And both in oral argument and in written opinions, I think, I believe it was in the early Biden administration. It might also have been before that. It might have been even in the Obama administration. I have a faint recollection that Chief Justice Roberts expressed displeasure at the change of legal position that was due to nothing other than a change in administration. And they want to see some consistency between these administrations. And then the third reason is that, you know, the government's not going to give up power if it doesn't absolutely have to, and it doesn't really make any difference whether there's an R or a D in the White House in that regard. These administrative agencies exercise so much authority that it would be surprising indeed if a federal official were to come out and say, you know what, we completely disclaim this power. There's no incentive for them to do that.
Got it. Backing up a little bit from oral argument, or to a couple of the overarching things that got referenced, we had several precedents that were raised, although none were technically considered on point, I think. There was Free Enterprise Fund, Collins, Arthrex, and Hartwell were the four I flagged. Can you give a brief primer on what those cases are in relation to the conversation here, and how they were being treated during oral argument?
Well, the reason those cases don't really answer this case is because in most of those cases, removability was seen as really the most important, overwhelming criterion, free enterprise fund particularly. And Arthrex is a little bit more important there. And in fact, I'll give a shout out to my friend Damian Schiff, who published a law review article on this that those who are interested should look up about what Arthrex means in terms of the appointments clause and removability, and anticipated some of the arguments in this case by saying it can't be the case that removability alone is enough. But I think the Arthrex in particular, I think, is the case that says the question can't just be the removability of the official. It has to be the removability on this issue, right? It has to be if you are a bureaucrat with power over issues A through Z, but you're only removable for issue T, then all the other issues, you're the end state as far as government is concerned, and that means that you are a superior officer and have to be appointed in accordance with the appointments clause. And Arthrex is the closest the court has come so far to making that point.
Got it. Well, you touched a little bit on this in your sort of summary of the case, but the nature of the term independent came up a bunch during oral argument. We got at least 3 definitions, maybe more. You seem to have Justice Barrett, who had a very stringent definition of it. Then the petitioners had one, and the respondents had one. Can you give sort of a breakdown of those, and then what independent means, or at least what independent seemed to mean?
Right. I wish I could, honestly, because you're absolutely right. It was like it's obviously it's the term that everybody's scratching their heads about. What does it mean for a person to be independent and therefore subject to the appointments clause is what this case all really turns on. And again, just to remind you, here's what the statute says. All members of the task force and any recommendations made by such members shall be independent, comma, and to the extent practicable, comma, not subject to political pressure. So independent, for one thing, it doesn't seem to mean not subject to political pressure, because if that's what it meant, then it would be redundant. So we shouldn't read the statute that way. So independent, but not in terms of political pressure. Well, then independent of what? Now, of course, the whole theory behind the administrative regulatory welfare state is that the government should be independent of the voters, because the idea is we have experts come in and they're going to tell us how to run our lives, and voter control only interferes with that by introducing political pressures, which are bad. And so one could be cynical and say independent means independent of Americans. You could also say independent of the regulated industry, right? If they're regulating medicine, then independent of doctors. But the statute doesn't say that. I mean, it would make sense for you to want the agency to be independent of the industry that is being regulated, so that they aren't engaged in capture of the regulatory agency. But the statute doesn't actually say that. So I think the answer is that this is another artifact of the weird history of this statute, that it began as a recommendation statute. And in a recommendation statute, you want recommendations to be independent. And there are many statutes that have that same kind of model. Just last year, for instance, I worked on a case involving the members of the boards that oversee the military academies. You know, there's these boards that are chosen by the president and Congress to visit the military academies, West Point and all that, and make sure that they're operating correctly. And they write a report, and it goes to the Congress and the president. And it's just a report. They don't exercise any kind of regulatory control. But the statute that creates this board says they should exercise their independent judgment. And that's what this statute originally meant when it was originally. They're supposed to exercise their independent judgment. And so you could say it means they're independent of each other, right? The members of this board should be exercise their own autonomous judgment. And I think that's what the government's answer in this case, in the oral argument this week, that's their position, is it just means independent of influence from outside. But that isn't what it means once you make an agency make an agency with regulatory power. Once you give these people authority to make rules that become law, then independent means something with more teeth in it. Now, in our brief that Goldwater Institute filed, we pointed to a number of statutes that use this same to the extent practicable language and all this sort of thing. And in none of those statutes was to the extent practicable intended to apply to the term independent or to the previous term or something. So we don't think that it means independent to the extent practicable. It means truly independent in some way. And that just has to mean, I think, that these are autonomous decision-making individuals and therefore should be chosen by the president and confirmed by the Senate. But you're right. I mean, that's kind of a long, rambling answer, because what does it mean in this statute? Given the statute's history, it really is not clear.
Well, we had an hour and a half of oral argument, much of which focused on this issue. So you're going to cover it in a couple of minutes. That's a breakdown of sort of the ways in which it was addressed. A couple questions on the argumentation of the respondents is put forward by Mr. Mitchell, one of which is put forward by an audience member on this exchange concerning the circularity or lack thereof of the argument. There was a charge before that the argument was circular because it started with, well, they're independent and they're independent because the accident went around. Could you give a brief recap of that exchange?
Yeah, I think,
and how it fits into the oral argument conversation more broadly.
I think it was Justice Jackson, I think, who asked that question. But, honestly, I did not think that was I didn't see as much force in that allegation as you might expect, given my opinion on this case, because, any well-crafted, logical, holistic view of a statute is going to appear to be circular to some extent, because it's going to be self-contained. If you look at a statute, if you have an interpretive theory of any statute that is makes sense and is well crafted and is round and impervious to counter arguments, then it's going to look circular. And I think that was the phenomenon that was going on here. I don't think the government's argument is necessarily circular. They're saying that that they're not truly independent is what the government is saying. They're saying their interpretation of the statute is all members of the task force and recommendations made by such members shall be independent to the extent practicable, is basically what they're saying. And so it is fallacious, but I don't think it's circular. I think it's fallacious because the grammar is wrong. It's not that to the extent practicable. That's the weakness of that argument. But to say it's circular because, well, they're independent. How do we know they're independent? Because the statute says so. It doesn't strike me as as a circular argument.
Got it. Another question on Mr. Mitchell's argument. I know there was, so you mentioned it was interesting to you that there was this conversation on whether or not the secretary can appoint. And I think both sides addressed it, but there was an argument put forward by the respondents that it didn't, even if the board are inferior officers, nevertheless, they still have to be presidentially appointed and Senate confirmed, if I understood the argument correctly. What is that? How does that fit in? And what would that mean for the outcome of the case? Or am I wrong? And can you correct me on that?
Yeah, I don't remember that part. Like you said, it was an hour and a half, so maybe I missed that part. I think, yeah, I'm afraid. Do you recall exactly what the language was?
Oh, I think it was sort of going through the hypotheticals of three questions. One, they're principal officers, I think was the argument. Two, even if they aren't, they can't be appointed by the secretary. And then three, even if we lose on both of those, say the respondents, this 13-year gap ending in 2023, that doesn't matter. So it's sort of like a three-tiered, if we grant this, then this, if we grant this, then this. But it may not be relevant given that the primary argument is on principal versus inferior officers.
Yeah, I do think it's a very curious thing that the statute is silent about how these people are chosen, that everybody has just assumed that convene means to select the members and to appoint the members. And I think the questions that came up, Justice Gorsuch, I think what he has in mind is a possible remand to address that issue. And because there was a lot of talk of remand during the oral argument, there was a lot of talk of, well, maybe we should clarify how this all operates and so forth. And so it wouldn't surprise me if at least some of the justices are contemplating going back to that. But the fact that, here's the thing, if there's no language of appointment, then that leans in the government's favor, I think, because if the statute doesn't refer to them being appointed in the first place, then that means the statute doesn't really contemplate them being authorities who exercise any kind of a power or something. And And it doesn't. I mean, the statute doesn't contemplate them that way because the statute contemplates them as just being advisors. And the statute was then conscripted, so to speak, by the Affordable Care Act into being a regulatory agency, which it wasn't ever intended to be. So in that sense, then that kind of leads to, well, maybe the problem with the statute isn't how it's chosen or any of that stuff. Maybe the problem with the statute is this other provision that says their recommendations are automatically become law. And that's true. I mean, if you fix that, I think even if I remember right, even the petitioner's lawyer, or I keep saying that, the plaintiff's lawyer in the case, a couple times said if that is the problem, if you eliminate that, the rest of the statute's constitutional. They kept saying under this statute is constitutional. It's just that there's this fact that they get their decisions automatically become law. So.
Got it. I think you hit it on the head, actually. I found in the transcript where he's talking about...
you see, that's the clever point about long-winded answers. It allows the other person to flip through their question. You notice this during the oral arguments, too, sometimes, you know.
Well, or except, because it's the conversation on even if you grant that they are inferior officers, not principal officers, the respondents would nevertheless argue that because the statute doesn't grant the secretary the power of appointment in this case, that isn't given to the secretary, and thus they'd have to go through standard appointment means. And that whole conversation is like, hey, but we didn't address this in the lower court because we never got to that issue, and so potential remand. Hence the you being correct. Last sort of question on.
However, let me interrupt to say I don't see, although I do think they're contemplating remand. I don't see how a remand would solve that problem, right? Because let's say that they can't be appointed. Now what? Well, then the statute's still constitutional, right? Then that's an affirmance. I don't. It's just for a different reason. I don't see how the lack of an explicit appointment power would have any bearing on the outcome of the case. Maybe I'm just obtuse, but if they can't be appointed to begin with, then what? Then that means their appointment was invalid, and if their appointment's invalid, then that means affirming the decision below, right?
So that actually leads me into the sort of last bucket of questions I have, which is what happens next? What could happen next? There's a whole bunch of questions on the table. What type of officers are this board? Who can appoint them? If anyone, even if they are inferior officers and the secretary can appoint them, what happens for this 13-year period where there was a board appointed by a director and not by the secretary, which both sides seem to agree that the secretary kind of has to do the appointing in this case, at the very least. So in that, just general remarks on the where we could be going. And then I have a couple of questions based on some hypotheticals.
That 13-year gap is something that the plaintiff's lawyers was working to reassure the court that it wouldn't be the end of the world, right? And it really wouldn't be, because the answer is, well, you get a new board that's appointed the way that they're supposed to be appointed, nominated by the president, confirmed by the Senate, and then that board just goes and says, yeah, what those guys did back there, we think that's fine, and ratifies it. Problem solved, right? So that's their position, is that it could be ratified subsequently by a constitutionally appointed board, and that would be the solution to the problem. And that seems pretty plausible to me. But the bigger picture of what effect would a precedent have here is an important one because of the pressures, the political economy of the regulatory state, if I can be so wordy. That is, the Congress wants to wash its hands of responsibility whenever possible. That's its incentive, is to wash its hands of responsibility while taking credit for good decisions whenever possible. And so that is why you have delegation. That's why Congress often delegates power to the executive branch. And that's why Congress very often creates task forces, as they call them, with a power to make recommendations independent that just are automatically made into law. Now, the pioneer in this was the base task force. I don't remember its specific name, but it was to close military bases. This was back at the end of the Cold War. You know, the idea was, well, Cold War's over. America faces no more international threats. The Russians are our friends now. So what we'll do is we'll close all these military bases that we don't need anymore. But no congressman wants the base in his district to close because that's bad for the local economy. And so they will always vote no on the closure of any particular military base. So why don't we create an agency, a board, a task force with the power to recommend which bases are no longer necessary? And this agency will be independent of the voters. And then it can write these recommendations, and those recommendations will become law. Now, that's not exactly how the base closure task force worked, but that was the basic principle behind it. And as I mentioned, the Obamacare did something similar with regard to what kinds of services the government healthcare programs would pay for. And so the idea of creating these sort of autonomous entities that exercise power so that Congress doesn't get the blame when it makes a decision that's politically unpopular, there's a lot of incentive in favor of doing that. Congress very much wants to get rid of its power and give it to other people so that it can take credit for good decisions and then blame the other people for any bad decisions or any unpopular decisions. And so we see it in a wide range of areas, and this task force is kind of an example of that, although it has this different kind of history than the base closure task force. So the precedent that the court sets, if it says, no, removability is not the end all be all. If they make the final call, then they're superior officers, and therefore they have to be nominated by the president and confirmed by the Senate. That slightly curtails Congress's power to wash its hands of politically complicated problems and forces responsibility back on Congress. So that could have an effect. It could have a very significant effect in a wide range of areas that have nothing to do with, preventative healthcare services.
Got it. So drilling down a little bit then, what is the outcome if the court sides with the government in this case? This is fine. It's been set up the way it's supposed to be. The secretary can do this. What changes, both immediately for the parties in this case and for the nature of inferior officers is considered more broadly?
Yeah, I think what happens is that, of course, if this is constitutional, then those 13 years of recommendations that we mentioned will remain in effect, and insurance companies will continue to be required to provide the services that were specified in the past. But as far as the next step, I think what will happen if the court is fine with this setup is that you will see more of this kind of thing. You'll see more of Congress convening these groups of experts to decide what is and is not going to be mandated automatically as a matter of federal law. And that's just a sort of a form of delegation, right, of government authority or responsibility to more and more of these subgroups that are not really answerable to the American people. Those of us who are really concerned about the so-called administrative state point out that it's not just a danger to liberty, but also a danger to democracy. It's not only is it a threat to individual freedom because these entities have the power to write and enforce laws on all of us that restrict what we are and are not allowed to do, but it's also a threat to democracy. And even progressives should be concerned about this, that you have these administrative agencies that are all basically at the behest, in theory, of the president, and sometimes not even there, that are going around making rules that change from administration to administration sometimes rapidly without any real rationale behind them sometimes. And then there's no real democratic control over that. That's something that should worry everybody who takes seriously the constitutional principles of limited government and voter control.
Got it. Well, I'll ask the reverse question then. What is the immediate and then more extended outcome of this case if the court rules in favor of the respondent?
I think the court is kind of on a roll on these administrative state cases. Well, obviously, the big blockbuster recently was Loper Bright, getting rid of Chevron deference. But I think we're only going to see more of them. Justice Gorsuch had a big reputation on this issue before he got nominated to the court. It's why he got nominated to the court. And I think the court has been anxious about this issue for since before that, right? Even I'm thinking of a case like FCC versus Arlington, the case that Justice Scalia wrote the majority opinion on, rejecting the theory that administrative agencies get deference when it comes to the finding of jurisdictional facts. To cut through the legalese there, what that means is if an agency can decide whether or not a fact exists, and then its power hinges on the existence of that fact, then should we defer to the agency in its determination that that fact is in fact true? because then that means that they get to be the judge of their own power. If the agency's power goes into effect if, a person wears a yellow raincoat, then do they get to decide whether or not the raincoat is yellow, or should the courts look at that rather skeptically? Because after all, if the agency finds that the raincoat is yellow, then all of a sudden they're vested with all sorts of power that makes them the judge in their own case. That was a real problem, and yet Justice Scalia was okay with that in the Arlington case. And Chief Justice Roberts wrote the lead dissent in that case, saying these agencies are really powerful. We should be really skeptical of them, and that was before Justice Gorsuch. So I think we've seen momentum building behind a real pushback against these very undemocratic agencies. And I think if you see a loss for the government here, you're going to see more and more of the court pushing back against these agencies. Now, I will say, SCOTUS blog yesterday, I think, they posted about this oral argument, and they were of the view that the argument went well for the government, and that the court seemed inclined to rule for the government. I did not read the argument that way. It's true that there were some skeptical questions from the justices, but I think it was about 50-50. And my impression was that although the justices were sounding out the plaintiffs in the real contours of their case, I did not get the impression that they were inclined to rule for the government here. I think it is true. I should add, I'm sorry I'm taking so much time, but I should add one other point, which is I do think that some conservatives are a little nervous about going beyond the removability criterion as the end-all be-all of this issue. I'm thinking about Justice Thomas, for example. The reason for that is that they're worried that if the agencies aren't making these calls, the courts are going to be making these calls. And so it seems in at least some cases that you're talking about transferring more power to the courts if the agencies don't have that power. Then it's going to be the courts making the ultimate call. And there's a lot of worry about that. The other reason is because political conservatives tend to like bright line rules when it comes to the law, just generally speaking. They like it to be an either or thing rather than a sort of realism, all things considered kind of an approach. And here the plaintiffs are making the realism, all things considered kind of argument instead of the bright line rule, which is removability. However, as you said earlier, even the government's lawyer backed away from the bright line rule in this case. So I think all things considered, it sounds to me like a possible win for the plaintiffs with a substantial dissent saying, well, it should just be removability alone. But, time will tell.
Well, I want to circle back around to that point because I usually end with your predictions. But before we get there, I'd love to ask a last question on the sort of secondary and perhaps more ameliorated potential outcomes, one being remand for consideration of questions not yet answered, and the second being this is constitutional asterisk only when the secretary is involved, so that 13-year period, those are unconstitutional, but its current form and moving forward it is. Could you give just a brief discussion of what that could look like, and then what effect, if any, that would have on the this case in particular, as well as the conversation on inferior versus principal officers?
Yeah, the latter thing that you mentioned strikes me as not an impossibility. I think it is possible that the court could say things are okay now, but in the past they weren't. Now, remember, in other cases, in previous cases about the appointments clause to these agencies, it's been a little frustrating for litigants because the court keeps doing this thing where they say, yeah, this agency was unconstitutionally appointed, and then sends it back to the lower court and then doesn't say what to do. And it doesn't give them any instruction on, well, does that mean that all their rules are invalid? And the Supreme Court seems to be refusing to answer that question. Well, and probably part of the reason is because they're afraid of that all hell's going to break loose if that happens. And well, at some point, I'm sorry, but at some point you have to pull the string. It just strikes me that if these agencies are unconstitutional, then their decisions are invalid, and the court just needs to go ahead and say so. And so we'll see what they say about that. But it has been a frustration for, 10 or 15 years now, since the court's been getting into this appointments clause stuff, that the Supreme Court has not been instructing people on the consequences of a ruling that an agency is unconstitutional. And I've now talked so much that I forgot what the first part of your question was.
A remand for questions not considered.
Yeah, the remand. So one of the issues about that both sides were kind of okay with was if the court does decide to remand should it remand on how to resolve this problem? There's this issue about severability. How much of the statute is severable? You know, if you say that small part is unconstitutional, does that mean the other parts are unconstitutional and that sort of thing? It's a question that comes up in lots of different contexts when the court finds that a provision of a giant statute is unconstitutional. Does that mean the entire statute is unconstitutional, or just that one provision, or how much can you carve out? And the problem with answering severability questions is that it's guesswork. What the court is very often doing is it's saying, well, would Congress have wanted this law to be in place without the removed portion? And how do you answer that? Now, the most famous case on this issue, of course, is the original Obamacare case, NFIB versus Sebelius, where the dissenting justices get into this at some length and say, you can't answer this question because this law was put together, patched together in out of so many different parts. And, you know, every last vote counted to get it passed. And there were these weird little bailouts and carve outs and payoffs embedded into it to get every last senator's vote. It's impossible to say whether Congress would have voted for the thing absent that provision, because every congressman and every senator wanted their particular pork barrel project to be inserted in there. So if you carve out a pork barrel project that would cost you a vote, then is it legitimate to keep it in place? The problem there is the court is basically rewriting the law. And so that's one of the reasons why everybody hesitates to remand on and decide, you know, severability questions and things like that. It would just be cleaner for everybody concerned for the court to say this is just unconstitutional, and the decisions they've made are unconstitutional, and the cleanest way to solve that is to appoint these people constitutionally and then have those new people ratify what was done before.
Okay. Well, that brings me around to where you were a couple questions ago, and my last question, barring any from the audience or any final comments, which is, do you have a read of how the court will come out? I'll ask, do you have a sense of what that breakout will be? 5-4, 6-3, and what the key or determinative points at issue will be in those decisions or in those opinions?
You know, it's funny. I should have done the math before this podcast to see if I could think about who's going to decide what. I'm going to predict. I'm going out on the limb here and predict a win for the plaintiffs. That is to say, an affirmance of the decision below. And I'm going to predict that it is 5-4. Three of the four dissenting justices will be Jackson, Sotomayor, and Kagan, and that the fourth dissenting justice is going to be, let's say, Barrett. Now, I find, maybe it's just me, but I find Barrett very hard to read in oral arguments. She's really good at using oral arguments to just truly sound out what people think about things instead of like telegraphing or setting off fireworks about what her own views are, the way some justices do. Some justices use oral argument as an opportunity to speechify. I think we heard a little bit of that yesterday, didn't we? But Justice Barrett doesn't do that. So I find her very hard to read. And I'll also add that it would not surprise me if we get a fractured decision with some of the justices saying that the fact that the statute is silent about appointment is also a problem. But I don't see a justice saying, yeah, this is perfectly fine except for the absence of the appointment thing, because nobody briefed that. So I don't think you'll see that. Maybe somebody will call for a remand for that reason, but I don't see the court using that as the final ruling. I think you're going to see 5-4 with, let's say, Barrett saying, well, this is fine, but I'm bothered by the lack of an appointments power, or something like that. But this is all just reading the tea leaves. It was not to me clear, and even SCOTUS blog, I think they were also sort of, reading the tea leaves.
Got it. Any final comments then on the case?
No, thank you so much for having me on to talk about this case. I do think that it's a really healthy development that we're seeing people question the mechanisms of the administrative agencies more and more lately, because, as I mentioned before, they are a threat both to liberty and to democracy. And it's very important that we ensure not only that government stays within its boundaries, but that the voters have meaningful control over what their government does. And these autonomous bureaucracies are a serious threat to that.
Well, Mr. Sanford, thank you so much for taking this section of your afternoon and sharing your expertise and insight and breaking down this case and oral argument and where we may be going. Thanks also to our audience for joining and participating. Welcome listener feedback by email at fedsocforums@fedsoc.org. And as always, keep an eye on our website and your emails for announcements about other upcoming virtual events. With that, thank you all for joining us today. We are adjourned.